Good evening, everybody, and welcome to In Conversation with Ian Dutton. It's Sunday evening, 7:30, and we're right on the cusp of the end of our lockdown period here in South Africa on the most stringent level, and we're heading into some unprecedented waters as we start getting used to the idea that so much of what we take for granted can just be suddenly removed from us. And in a way, there's a sense of moving from one reality to another tonight. The lockdown is in my view, caused an international sense of disbelief. We live in an era where much of the world has known relative peace and prosperity. In the early 20th century, in short succession, there was the First World War, the Great Depression, and then the Second World War. Since then, there has not been a world war or international event which strikes at the order and security of human beings on a global level. So as we leave the confines of the lockdown, there's a sense that we're moving into a new era. The old certainties feel to have been challenged, if not shaken. And so it is in our country. We prepare for a new week with a sense of uncertainty and challenge. And yet, there is in the change also opportunity as the old ways slip away and the new normal gets defined. It is against this backdrop that we're having this evening's discussion. Over the past few weeks, I've had the privilege of hosting some of the leading medical and legal minds in the country. The tremendously positive reaction to this project is humbling and motivating. We'll also look back on the discussions over the past few weeks, and a couple of the people that have participated in those presentations are with us this evening. We'll be joined by Michelle Postman, who'll be dealing with some quite tremendous developments really in mediation, and in particular online mediation. But within the mediation area generally, there've been fast-moving change even during the lockdown, and I think that's a sign of things to come in the next few weeks and months. So Michelle's going to bring us up to date with the latest developments, and I'm looking forward to that. And then we'll be joined, and this is a discussion that I'm really looking forward to personally, by Louis Podbilski from LexisNexis. And when we're going to discuss the recent law reports, and over the past few months, there've also been some seismic shifts, and we can pick up some trends that are happening within the development of our law. And in particular, we're tying those trends into what's happening in cerebral palsy cases. So Louis and I will discuss that for some time. If you're not a lawyer, don't feel that this is not a discussion for you. We're trying to pitch this at a level that everybody can understand what's happening, because those movements in the law affect all of us, particularly if we're practicing within the medical law space or medico legal space, and it's good to have an understanding of the general trends that are happening in our law. So that's going to be really exciting. And then we're also then going to speak to Romany Sutherland, who does a lot of cerebral palsy work and just has a lot of general experience within medical law and medico legal work generally. And after that, we'll bring in Paul Delmeyer, who will talk from the obstetricians and gynecologists perspective. We're hoping to be able to bring in Johannes van Waart as well, but he's actually probably right as we speak performing surgery, and he was caught behind a coronavirus patient apparently, so the case before him might take a bit longer than expected, but he's hoping that he can make it. We'll have to see, but if not, then Paul will step in for him. So that's roughly the program. The idea is for us to look back and to have a bit more of an informal chat, and I'll bring people in if they want to contribute. There's a facility on your Zoom chat feature where you raise your hand. So if you raise your hand and we see your hand is raised, we'll bring you in to participate. But just for the first part of the conversation, let's bring, we're going to talk to Michelle and to Louis. So let's bring Michelle in and let's go through what she's going to discuss with us. Hi, Michelle.
Hello, Ian.
Good to see you again. Michelle, we had some really interesting conversations around mediation and developments in mediation over the last few weeks. And in fact, we kicked off the series of webinars with a webinar with yourself and Herman. Michelle, can you maybe just break down for us recent developments? There's been so much activity in this space recently.
There really has, Ian, and it's been very exciting to watch, especially from the strange place that has been locked down. So we started off with the introduction of Rule 41A just before we went into lockdown on the 9th of March. And it's a pity that the timing's a pity, because it wasn't allowed to gain traction as quickly as it could have had we been litigating in the normal fashion. But in any event, it was an exciting development and marked a tremendous shift in the way, in the dispute resolution cycle. We now have a new component introduced into litigation, which has been very exciting. And in fact, I've had a few queries during the lockdown period of attorneys wanting to issue summons and asking how they go about including the notice for mediation. So it is starting to gain traction. And there's been a lot of discussion during lockdown on Rule 41A, a number of webinars, and I think hopefully people, it's on everyone's radar and will become an integral part of our system. There's also been a lot of discussion around medical malpractice mediation, which is really exciting because I think it's the right forum for these kinds of disputes. There's been a lot of reference to the experience in the UK and how successful it's been there, and hopefully that's going to filter through either through the use of Rule 41A or independently pre-litigation for these disputes. There's also been developments in the field of personal injury, a lot of discussion between RAF and SAMLA about using mediation as a mechanism for these disputes, appropriately for expeditious and effective dispute resolution. Then in general, there's been a lot of focus on online dispute resolution and in general, and on mediation in particular. A lot of people have started using this platform, Zoom or Microsoft Teams, to start resolving disputes online. So that's been a very exciting development during this lockdown period, which created a perfect storm for people to shift to using this. So that's been quite exciting, and I'm hoping that going forward, once lockdown is lifted, that will become a normal mechanism or normal medium for dispute resolution. There's also been a lot of
because Michelle, what just one thing on that struck me when we spoke to Tony Allen is, the online mediation is not only the fact that we've been in lockdown, but he made an important point, and that is to do with the sort of geographical distances and the fact that online mediation, obviously that becomes much less of an issue. And I think there's also, what's been quite interesting is that so many people have been commenting on sort of working from home and what the experience of working from home has been like. And I think that there's been an exposure to people in their working lives to being able to use platforms like this, like Zoom, etc. And my sense is that that's going to be carried forward even once lockdown is lifted properly. I think from tomorrow we'll probably get a sense of lockdown being lifted. But I think it's become part of our working lives in a way. So I think online mediation definitely is a space to watch.
Correct, and I agree with you. I think a lot of people have become very comfortable with the platform and using it. So yeah, I really sincerely hope that it will remain as part of people's work method. Yeah. So another interesting
mediation advocacy. I mean, I think take us through exactly what you mean by mediation advocacy. I know that that's a particular angle, and we're all getting used to these terms, and we'll have to get used to the skills that are needed. But tell us your thoughts on mediation advocacy, and particularly what developments there have been recently.
So mediation advocacy is a very exciting new field for legal practitioners. I think it's generally acknowledged that legal practitioners are very important in the mediation process and have a very important role to play. So mediation advocacy is a new field opening up for lawyers to learn how to represent their clients strategically and effectively in the mediation process. So this requires of them to have a deep understanding for what mediation is and how it works, and how then they can position their client and their client's case within that space. Another term I've heard recently is settlement counsel. So definitely shifts towards legal practitioners gearing up to take their own place in the mediation space, which is really exciting.
Interesting development that. Yeah, I've also heard that settlement counsel, and it's interesting, just even the name shows a different approach and a different mindset. And as you pointed out when we did your interview, and also in the webinar, it calls for different skills. And we so, especially as lawyers, it's so ingrained in us to be sort of confrontational and to think of disputes being resolved through the litigation process. I think that's going to be a very interesting development to see that skill set developing within the ranks of the legal profession.
Very much so. And I was quite excited to hear in one of the webinars, I think it was Henrik Kotzer, who spoke about perhaps parties to litigation needing two teams, a litigation team and then a settlement team. And then the mediation advocates or settlement counsel would be part of the settlement team. And I don't know if you remember, Michelle, I'm sure Chris Marnovic would have taken you for legal drafting. And I remember Chris teaching us when we did pupillage that his attitude towards litigation, which sounded, we got into the real world, you wondered if it really was workable, but now it looks like it's coming sort of full circle, and this is the way it's going to, or could develop in this way. Chris used to say to us that when he gets to a trial, I mean, he as counsel wants to focus on the trial. He doesn't want to get involved in the settlement. He doesn't want to get involved in negotiations. And he made the point, and we referred to his book during our webinar, and it's amazing how far ahead of his time he actually was. I mean, he wrote in 2002. But he made the point that it's a different mindset. Litigating is a completely different mindset to mediating. And I know when I run trials, look, with personal injury work, you have to get involved in the settlement. But it's a distraction. And it's almost as if the moment you start talking settlement, that trial's not going to run, because some of the energy goes out of it. And you realize it's just a bit of posturing so you can adopt a more hardcore position. And so I think that split between litigation and mediation and differing teams, in my experience, if there are resources for it and if it's managed right, that certainly seems to me to be sensible and something that could well develop. Mm. So the next
sorry, you wanted to have a look at? Sorry, carry on.
The next very interesting and somewhat surprising development this last week was the introduction of this Regulation 13 as part of the regulations under the National Disaster Act. And so if we look at it, you've got it up here. The parties to a civil dispute against the state or any organ of state which may potentially result in litigation may either before or after the commencement of litigation, but before the granting of judgment by the court, agree to refer the dispute to mediation. So this was quite interesting because it's got similarities to Rule 41A, but it goes a little further, because Rule 41A kicks in once you're about to issue summons, so once litigation commences. This takes it one step before litigation and says before commencement of litigation or after or before granting of judgment. So there's a parallel with Rule 41A. The parties can agree to refer to mediation. And then it also says before litigation, they can agree to refer to arbitration. So it's introducing another component beyond 41A. So
Michelle, just to orientate ourselves, so when Regulation 13, resolution of disputes, what sort of disputes does that contemplate? Is that only in terms of the Disaster Management Act, or is it broader than that?
It's not clear, Ian, and we've tried to make inquiries with the State Attorney's Office and the Office of the Solicitor General where this seems to stem from, but and it's not clear. So what we do know is Rule 41A refers to all civil disputes, and Regulation 13 is only disputes against the state.
But I agree. What seems to be interesting here, and a point that you just made, Michelle, what's very interesting about this is that, so here we've got brand new legislation which seems to be embracing this multi-tiered approach. And in fact, as you've quite rightly said, looking at the provisions here, they've actually taken a further step forward. So it looks as though, certainly from the state's perspective and from the legislature's perspective, they're starting to really get their arms around this concept of a multi-tiered approach.
100%, and I'm delighted because when we started off this lockdown period and our discussions, we were talking about a shift to a multi-tiered approach with different components being integral to a dispute resolution cycle and being used interchangeably. And so here we've got arbitration or mediation before litigation, mediation during the currency of the litigation as an option, and then obviously litigation as your backstop. So 13.2 says, where the parties agree to mediation or arbitration, the Office of the Solicitor General will assist in coordinating and overseeing. And then, interestingly, the parties may agree that a judge who has retired shall act as mediator or arbitrator, and then no fees will be payable. So what is envisaged is that there's going to be no additional expense to parties to encourage them to use mediation and arbitration. Now, obviously, there's a little bit of a concern from the mediation fraternity and a question around whether judges are equipped to mediate effectively. Obviously, arbitration they can do quite comfortably. And one wonders whether judges are going to do or perform these services for no remuneration. But in any event, it's there, and it means that there's a commitment from the state and that they're thinking along these lines, which is very positive.
Yeah, and because it's in terms of the Disaster Management Act, they almost like let them push the boat out and let's see what actually happens and what maybe they might encounter some challenges, and they learn for future initiatives.
And then the last part of that regulation says that the state attorney's office in the area of jurisdiction where a dispute arises, as soon as they become aware of that dispute, they've got to engage the party or legal representative to consider mediation or arbitration. Now, it's difficult. We don't know the context for these regulations or what the thinking was. But they obviously, well, I would imagine they're trying to relieve a growing backlog in the courts, and they want to encourage parties to use these different mechanisms to try and resolve the disputes that are pending, which is very positive. So hopefully this signifies a significant shift in the way forward.
Yeah, I agree. It's a specific example of a more general mindset change. And I mean, you referred a few minutes ago to the RAF, and I know Herman is watching this, and I'm sure you'll bring him in later. But there's some huge developments in the RAF, and the RAF is still by far the biggest litigator in the country. And so I think that if we're seeing this in these sorts of Disaster Management Act regulations, that to me, what's really telling about it is that we're seeing a shift in mindset in the state, and I'm seeing that running through. And now your absolutely apt quote, Michelle.
Yeah. So. Fellow mediators, I want to say our time has come. We've been waiting a long time, and we've thought before that it had come. But I think there's a lot of indicators at the moment to say it's our time. Hopefully.
Very good. Okay, no, very nice. Okay, Michelle, just any final thoughts then to wrap up that section on what's happened with mediation.
I think I've said it all, Ian, and I'd like to end with saying our time has come. It's time now to embrace this mechanism and see it fly.
Yeah, and I mean, I really would endorse that, it seems as though it's becoming unarguable that mediation is now going to find its rightful place in whatever form it eventually settles down into, but it will have its place within the panoply of how disputes are resolved. Thanks so much, Michelle. Great seeing you as well. Eh?
Thank you.
Okay, cheers in. Bye-bye.
Cheers. Bye.
All right, and now I'm really looking forward to this discussion. Our next guest is Louis Podbielski. Hi, Louis. How are you?
Hi, Ian. Thanks for bringing me on board. I just love talking case law, as you found out.
Yeah, no, and what I love talking to you about with case law is that you really bring it alive, and you've obviously got a passion for it, And people might think that sounds rather strange, but wait till we get into it. It actually is so important, and there's so much happening at the moment, and we'll pick up on those trends in a minute. But the trends that are happening at the moment in our law, and that we can pick up from the decided and reported cases, is almost on a monthly basis. We're seeing some threads coming together. Louis, I think maybe just to start off with, just introduce a little bit yourself a little bit. What you're with LexisNexis? What exactly do you do, and how are you going to tie that into what you're going to talk about tonight?
Well, I'm actually incredibly lucky. These LexisNexis pays me to spend a good amount of my working day just reading case law and writing about it and working with it. I'm really, really lucky. And what's really been amazing when we're looking at these medical negligence cases is, as a law reports editor, when you report a case, you've got to compile the annotations. So all the cases that your reported case refers to, you've got to really unpack them and decide, are they being referred to, applied, distinguished, not followed? And then what else you've got to do is the referenced case, you've got to decide which part of it, which is important, because an earlier case might be referred to for different parts and different points of law. So we get tuned in to seeing patterns and trends in case law. And all of that data we capture, it actually gets ingested into the legal citator, the Lexis citator. And there's over 90,000 cases in there, going back to the 1828 provincial cases, the old appellate division, 1910. So it's actually like a neural network of connections, of later cases referring to earlier cases, which refer to earlier cases. And seeing the patterns, it also comes into when we do selection, because when we're doing case selection, we pick less than 1 in 10 for our flagship of the about 3,000 we receive every year from all the courts. So when we receive a case, we have to decide whether it's reportable or not. And there we have to compare it to the entire body of law that we've reported before to see if this case has got a new point of law, or takes the law further, or interprets it. So that whole pattern identifying trend, it's deeply ingrained into us. And funnily enough, the search results you get on my LexisNexis, I don't want to really reveal too many of our trade secrets, but when you type in a keyword search and it goes into the system, say you're looking for cerebral palsy cases or pure economic loss or something, that entire neural network of 90,000 connections gets tapped into, and it's very clear the algorithms and rules that it draws on that to try and rank your search results. And that's what I've just found so exciting. Since you did that article for LexisNexis on the Mayer case and the Protagoras story, we've been chatting about cases, and you and I just pulled 4 or 5 cases to discuss this evening, and that is actually just the tip, because they're recent cases. It's actually just the tip of a pyramid of precedent going down in medical negligence cases, and it's just fascinating the trends we're seeing on the onus and causation, and there's other trends as well.
Right, Louis. So let's start off with let's say that there's my smiling face. And you know, I just wanted so what the first point that I'd like to make is that we're going to have a look at some trends tonight. That's really what we're looking for. We're not going to go into the sort of the technical legal side of it too much as we, you know, if you were arguing match in court. We're looking for overall global trends, because that's what people, you know, that are watching tonight are going to be interested in, and it affects everybody. So I just wanted to refer to this article, and for one reason is that this article is premised on this decision, which is Myers versus MEC Department of Health. And I mean, the article is on my LinkedIn site. It's on your LinkedIn site as well. If people do want to access it, I'll put it on my website as well. But but the important thing about Myers's case is that it demonstrated that the SCA, and in my view, it's unprecedented, Louis, shifted the burden of proof from the plaintiff to the defendant. And what I mean in particular, for just so that everybody's clear, is what the SCA said is, instead of if we don't know what the cause of the injury was in a medical procedure, at the end of the day, the trial has been held, but we can't establish the exact cause. Then we'd always understood the law to be that the plaintiff had to then the plaintiff would lose if you couldn't establish that cause. In Myers, what happened is that they couldn't establish the cause, and 3 judges out of 5 in the SCA said that that means that the doctor loses, because the doctor must now prove that he or she wasn't negligent. Now, to my mind, that's a seismic shift, and we'll have a look at some of the cerebral palsy cases. But it seems to me that if that is what the SCA is going to continue saying, then firstly, that's a huge change in the law. But secondly, in my view, this message then needs to be communicated to the healthcare profession, because they then need to start making proper records of what has happened. And they must be aware that they need to explain what happened and that they're not negligent according to that decision. I know what your reading is, Louis.
Yeah, it's interesting, the cases we've looked at. For example, we've noticed that, I just want to mention the Ian Dutton case, which was March 2019. That was by Judge Griffiths in Eastern Cape Mthatha Court. And that was a cerebral palsy case with asphyxia. And there, Griffiths didn't really look at causation. There they had 3 experts, and he emphasized that if the plaintiff raises a prima facie case of negligence, the onus passes to the defendant to rebut that. And in this case, the 3 experts found the hospital's care so substandard that there was no doubt about it, and it just kind of skipped the causation part. And then,
yeah, absolutely, Louis, and you know, that's something that we saw a few years back, and I thought this is why this case was interesting. I mean, it was decided about a year ago, and excuse me, but what was interesting about it in particular is that the question of causation didn't. Sort of a few years back, the question of causation didn't really play much of a role, even in cerebral palsy cases, and you can see it in this case. So you'll see, for instance, look at this, held that the only issue on the question of liability was whether or not the cerebral palsy which afflicted the child was caused by the negligent treatment of the plaintiff during the course of her labor after she was admitted to the hospital in full labor, and then they go into where the plaintiff is, at the bottom here, where the plaintiff has presented evidence which of itself raises, at the very least, a prima facie case of negligence on the part of the defendant's employees, the evidential onus passes to the defendant to rebut such prima facie case and to explain how the injury came about. Although they focus almost exclusively on negligence and really don't get into the question of causation at all. And I just want to finish, just before you comment on it, Louis, I just want to take you to the findings eventually, which Judge Griffiths makes, is that he says that the only evidence which I have before me at paragraph 21 is the evidence of the 3 esteemed medical practitioners. From their evidence, it emerges as a high degree of probability that the HIE occurred during the last 2 hours of labor, and that during this period there was no monitoring of the fetal heart rate and other vital signs. As I've indicated previously, both the plaintiffs and defendants' gynecologists are at idem that this amounts to substandard care. Now, that's negligence, right? And then there's no doubt that this, and the next sentence then is, look at how this was dealt with traditionally by the courts. There's no doubt that this failure on the part of the employees of the defendant was the direct cause of Simamkele's asphyxia and consequent cerebral palsy. He just almost takes it as a given that once you've established negligence, you know, it's almost going to follow that there's a causal connection. I don't know what your views are on that, Louis.
Yeah, no, I noticed that as well. Once it was clear that there was negligence, there wasn't another further step or unpacking. And some of the recent cases we've seen, the judges take quite some pains to first deal with negligence, and then even under paragraph headings, they'll then deal with causation. It's just,
if we have a look, then let's contrast then AN versus the MEC for Health in the Eastern Cape, and you'll see that in this case, the High Court held that the appellant did not prove that the negligent failure to monitor her and the fetus had caused the damage. The claim was thus dismissed. And so here we see now a completely different emphasis. Here, they're zooming in on factual causation. They're zooming in on the causal connection. And we're seeing that in cerebral palsy cases, that causation has come much more to the fore.
Yeah, this case is also very, very much about factual causation. And what's so interesting is the Myers case was split 3-2. And this case, it's so fascinating to read this. I just love case law. 4 of the judges held that there was a sentinel event, a sudden event, and they held that the monitoring and causing a quick birth, it couldn't have saved the baby. They said it cannot be said that the creation of risk by the negligence of hospital staff caused the brain damage suffered by the baby. But those 4 judges, they covered all of that in paras 1 to 29. And then Judge Molemela, he went to some pains from 30 to 71, quite at length, and he goes into incredible detail on the expert testimony and expert articles. And he is quite adamant that he disagreed with the others. And he actually says, the evidence adduced on behalf of the appellant, together with the department's expert witness, unquestionably prove both negligence and causation on a balance of probabilities. So here you've got just one who's very, very detailed and very adamant that there was negligence and causation. And
if you have a look, you look at from paragraph 47 onwards, he deals at, as you say, at length with causation. Let's just have a look. Let's just move on then to, so that's the dissenting judgment in AN, and you can see how causation is coming to the fore. And then I just want to turn to our next case, which is if you just bear with me, this is Nondonga. Also out of the Eastern Cape. A lot of these decisions are emanating out of the Eastern Cape. It's one of the notable features as well, Louis, is a lot of these matters are from the Eastern Cape. But anyway, if you look at 14, what's interesting is that on the plaintiff's own version, the cause of the outcome to Olotando is unknown. So here we've now got, and this is where the thread starts emerging. We've got the actual cause of the injury, but now this is in a cerebral palsy case. The actual cause of the injury is unknown. And that now immediately makes one think of Myers's case, where the cause of the injury was also unknown. But of course, the Supreme Court of Appeal made a decision in that case that the doctor had to explain. The reasoning in this particular case was different. They approached it on the basis that it was for the plaintiff to establish. If the plaintiff couldn't establish the cause, the plaintiff would lose, which in fact happened. But this is a decision from a single judge, and the Supreme Court of Appeal trumps the single judge. So it's, to me, going to be interesting to watch this judgment as it moves up through the courts to see what happens with this principle with regard to cerebral palsy cases, because that is where there are massive potential implications. Because if the courts are going to say that in cerebral palsy cases, like in Myers, effectively the doctor's got to prove what the cause was, otherwise he or she is going to lose the matter. That has huge implications for cerebral palsy cases.
Yeah, and interestingly,
what's your view on that?
Yeah, what's interesting about this recent case, and I mean it's really fresh. 22 April, is there was just, the judge couldn't find negligence and couldn't find causation. There was, on this one, there was just literally, once you go through it, a very little chance for the plaintiff. And funny with the Myers, the split, that case, that the previous SCA case where there was a 4-to-1 split, they actually reference an earlier Supreme Court of Appeal case, AM versus the MEC Eastern Cape, that was handed down in October 2018. And that case was a cerebral palsy case, and it was also split 3-2. And that was on factual causation too. 2 judges found factual causation proved on balance of probabilities, and 3 judges, now this went the other way, found that the failures complained of could not have caused harm to the baby. So now
correct, and what we're seeing is the split in the benches, and that's one of the points I make in Myers, in the article I wrote on Myers, is that to me that is a consideration which parties should take into account, because it's at the moment so unpredictable as to what the outcome of litigation will be, and that is a factor which, to my mind, promotes the option of mediation, because from the healthcare practitioner, the doctor's point of view, the last thing you want to do is get drawn into a long dispute which is taxing and difficult, and at the end of the day you don't know what the outcome could be. Louis, I just want to move now to the last point that we want to make, and that is this MSM judgment, which raises and continues a trend which has been emerging in our law for a little while now, but follows on from constitutional court authority, but effectively raises this question of the public healthcare defence, which is an interesting development which has come through. I'm not sure whether you agree with that and what your thoughts are.
Yeah, this is as well where we in the law reports have been monitoring this once and for all rule, because the once and for all rule goes deep back. I mean, in our case law precedent and in our system, and then since this constitutional court judgment, MEC for Health versus DZ in 2017, since that was reported, there have been cases called the DZ defenses, and this case, MSN, which is Judge Cately on 18th of December 2019, this has just tied it off, because the Constitutional Court case said that on the case before them, they couldn't develop the common law. But what Judge Cately has done is sees this case, and these are the conditions that we've been waiting for since the Constitutional Court case, is it's now ripe, and the court has developed the common law so that the damages don't sound entirely in money, and that compensation in kind by treatment at state hospitals has actually been allowed and ordered. Although the MEC in this case did actually ask for two-prong. The MEC asked for payment in kind and payment by installments, and Judge Cately didn't think that it warranted to go that far, so it was only the common law was only developed as far as allowing treatment in kind.
Yeah, and if you look at paragraph 205, which I've got on screen now, she actually found, in the circumstances, I do not consider it necessary to address the question of whether the once and for all rule should be developed to permit periodic payments in this case. That question must wait until a proper case is prevented on the issue. So we've got two issues that are sort of percolating here. The one is this periodic payments issue, which now we're waiting for the right case to see what happens with that. And the other one is the defence which you've referred to, which has already now got the sanction of the courts. So we'll see. We see that in fact in her order, she at 2071 says the common law rule requiring that delictual damages must be compensated in money is developed so as to permit a court to order compensation in kind in appropriate cases. And then she defines various circumstances. But the important point for present is that she recognized and endorsed that common law rule requiring that delictual damages must be paid in money can now be paid in kind. In other words, that services can be provided instead of paying money. And that's quite a radical departure and has important implications for cerebral palsy cases and for any personal injury matter, including medical negligence matters in general. Louis, any concluding thoughts as we wrap this up?
No, just there was one in your introduction when you introduced this in the Myers case. There was one quote from the case where the 3 judges found negligence, and remember 2 didn't. But the 3 judges who did find negligence, they ended, and there was one quote that really sort of underlined it, and it was, "No reasonable suggestion has been offered as to how the injury could have occurred, save for the negligence on the part of the doctor." So I find it's so fascinating. It's almost like there's like a scales or a seesaw with the onus. And we've seen now, just in the few cases that we've done, only going back 2 or 3 years, how it seems to me, when I read it in the different language the judges use and the different facts and the circumstances, it's almost as though that scale is shifting as we move from different cases. I think this
and Louis, you know what I know has been happening is that there's been a so to sort of wrap all of this up now through this little sort of flyover of these important cases. In summary, this is my view. So in summary, what we've got is we saw the sort of the old position where we saw that one judgment from the Eastern Cape where causation just didn't really feature, certainly in cerebral palsy cases, and is almost overlooked. And we've seen now causation moving front and center, and we're getting a lot of judicial activity on causation in cerebral palsy cases now. And at the same time, we're seeing the courts revisit this concept of where the evidential burden lies. In other words, if you can't establish what the cause of the injury was, then who loses? Because it often happens. And to my mind, it's a critical question. I know Pat van den Heever, the late great Pat van den Heever, I mean, he wrote a whole textbook on res ipsa loquitur. The courts haven't specifically referred to res ipsa loquitur, but it amounts to the same thing. In other words, does the act speak for itself? The court's taking a slightly different line here, and they're saying, well, if we don't know, who's supposed to explain it? And in Myers, for the first time, there's been a real shift away from the plaintiff having to explain it to the doctor having to explain it. And I think it's going to be fascinating to see how the SCA deals with that sort of question in the context of cerebral palsy case. And I know Romney's got some points on that, so I'm going to talk to her about that now. But that's the one thing. And then the other aspect that I found very interesting is the development of the once and for all rule. So now we're starting to see, instead of having to pay actual money for injuries, services, the courts are starting to accept that services could be rendered in exchange for money. There are various nuances to that, but that seems to now be taking root. So Louis, and then just to wrap all of that up, I think that's where we're seeing the important cases around medical negligence is starting to coalesce. And I thank you so much for your time and your effort. And it's always a pleasure talking to you. And thanks for bringing us up to speed in the law reports. There are 1 or 2 cases that I would love to have got to, but time just doesn't allow. And I'll find another way to put something on the site and to deal with. There's a very important mediation case that came out recently, Mabunda, that we haven't managed to get to. There's a judgment that Herman featured in where to do with EEGs and how one proves EEG. So there's a lot of case law, but we can't deal with it all tonight. So I'll put something on the site. But thank you so much, Louis, for joining us.
Yeah, no, thank you.
Okay, and then thanks, Louis. Thanks a lot. Just before we turn to Romany, I just want to bring people up to speed with what's happening with the website. as we come out of lockdown, we're moving now into a new phase. And so we've done a lot of these webinars, and they've really been interesting. And I think we must continue doing this. But we're actually going to be formally launching my website on the 28th of May. So that's in a few weeks' time. And in the lead up to the launch of the website, we're going to be releasing material, we'll be releasing content, and we'll keep those people. I think it must be close to over 100 email subscriptions already that people have signed up for, and that seems to be picking up momentum. So every day I'm getting more and more subscribers, and that's really exciting and gratifying on a personal level. But I'll start rolling that material out now over the next few weeks, and then I'll let people know via the newsletter when the material is coming on board, and it'll be specifically structured to the various professions. So discussions like what we've just had with Louis now, we'll capture that discussion, we'll get the essence of that discussion, and we'll relate it to whichever particular sector we're dealing with. So whether you're an expert witness, or you're a legal practitioner, or a healthcare practitioner, or a mediator, we'll take that discussion and relate it specifically to your field of practice. Okay, and now let's get Romany on board here. Romany, really nice to see you again. I hope you've got over the very animated webinar that we had the other night. It was fantastic. I've got so many compliments and positive comments, and how you guys were rock stars and you were a rock band and what have you. So yeah, very nice to see you again.
You too. Thank you, Ian. Thanks for having me back on.
Yeah, no problem. Romany, tell me, you've been litigating these cerebral palsy cases now at the coalface for quite some time, and I mean you're known as somebody that has real insight into these cases. From the sort of the coalface, from the actual practical side, give us your response to the cases and the points that I touched on with Louis.
Ian, I think just looking at the cases that you brought forward, it is quite scary to take one of these CP cases to court. We don't know where it's going to go, and these days, and to bring in mediation, to bring in specialized court to deal with these type of matters, I think is going to be more and more important. I do think the Myers case being an SCA judgment is a problem, but I don't know if a CP case gets taken to the SCA whether the same result is going to come as we know in the I think it was the AN matter, this SCA matter.
AN matter,
where causation. Yeah, where causation was so important. I think in the Myers matter, it was a common bile duct injuries, very small number of firstly defendants, and secondly, how that bile duct could be injured, as opposed to these CP matters where it's quite vast. The thing is, the next couple of years are going to be very interesting, because we're now bringing, as we heard on Thursday, the Better Obs and the EOP are bringing in these great measures where we're going to be able to defend these matters better. We're going to have more information which is going to assist us in the defense of these matters, i.e. the cord pH, to look at whether there is any metabolic acidosis, as well as the placental pathology, which we are learning more and more about, and that can show whether there was specifically some sort of infection that could be a cause of the cerebral palsy. So, with the Better Obs, with all of those tests coming in, it is going to assist us with specifically the question of causation. But still, it is, as far as I'm concerned, quite dangerous now to take these matters to court.
And Romy, that was the sort of point that I made in that article, and it's interesting to hear what Michelle had to say about developments within that mediation space. I mean, you and I have also been watching it closely, particularly from the perspective of medical negligence, and have been involved in efforts to try and get that ball rolling. It does look as though via the RAF there's going to be there is going to be some movement now, and that to me is an interesting area, and I'm sure that's something that we can look at down the line. But I know that Herman has been very involved in trying to get that various pilot projects going with the RAF. And, it does look as though, certainly from the reported judgments, there's a very real change in mindset from the Road Accident Fund. And I wonder whether it's possible to bring Herman in at this stage, Ashley. I see his name is up there. I wonder if he's...
If I may just comment quickly, Ian, in that respect.
Absolutely, yeah.
I mean, there's been a cerebral palsy matter, the merits part of the matter that has been mediated very successfully. But something that's very important and close to my heart is that you don't need to specifically be involved in a mediation in order to assess these matters carefully, or get to a settlement stage, or get to a stage where you actually have enough information in order to know where you stand in terms of risk. If you have two attorneys, plaintiffs and the defendant's attorneys, who know what they need to do to get, perhaps, rather than mediate the matter, use the principles of mediation. Get together, pick up the phone, sit across the table from each other and say, right, well, we've got this information. Who do you respect as a gynae to give us an expert report on this? Should we get this, or should we get the EOP? Even better, the EOP. Let's get the EOP. We have those two experts to assist us there. Then we get that report. Then afterwards, hey, let's go and look at what sort of injury this is. Was it a stroke? Was it an acute, profound, or a prolonged? Let's get a little bit of information, but let's keep talking at every step of the way. So what I'm saying is, the attorneys out there do not have to specifically get everyone around the table with a mediator in front of them. If you can do this together as the plaintiff's attorney and the defendant's attorney.
I mean, I agree with that, Romy, and Michelle spoke about a multi-tiered approach, and the first level will be an attempt at negotiation. And look, just from my perspective, where I get briefed by different size law firms and of differing capabilities, and I mean, I certainly do think that if you've got two attorneys who know exactly what they're doing, and they know the experts and they know the environment, that's important. You can do it that way. What I find is there's sometimes a mismatch where you get a firm of attorneys who say are very small, they've never done a medical negligence case before, much less an important or difficult one. They don't know anything about the experts, none of the issues they're really on top of. And I find that my thinking is that it's in that type of case, certainly, that you will find that a mediator can steer them possibly in the right direction, and provide some sort of insight. Herman, yes. Let's bring you on board. Nice to see you, Herman.
Hi, Ian. Before you ask me anything, I just want to agree with Romany and put it in slightly different words. It has been our approach. When I say our, I mean the Sanlam mediation approach, both in terms of RAF mediations and in terms of clinical negligence, that the first prize is a settlement negotiation between the parties that comes to a successful conclusion. And I think that all lawyers who are truly ethical and experienced and who are there to serve the best interests of their clients should be able to settle any matter by a constructive settlement negotiation. In that circumstance, I don't think lawyers need mediators. So here I'm talking against mediation, which is my passion, because I don't think one should be involved in anything which is not necessary. Where I see the role of mediation is when the two parties, for whatever reason, and there can be a multitude, but for whatever reason they cannot reach settlement through direct negotiation, then the mediation process and the skill and experience of the mediator is there to assist them in getting to that resolution.
Yeah, no, I agree with that, Herman, and it's going to be interesting to see how mediation finds its place within this space. But definitely those comments, I mean, we can't argue with that. Those are definitely absolutely right. Now, Herman, what I wanted to find out from you is, we've seen via the courts, and also there's been a lot of talk on sort of in the background about the RAF and its attitude towards mediation, and what could be happening within that space. And I know even tomorrow, I get back to my practice, and I've had quite a number of inquiries from attorneys who have a lot of cases and who are very interested in this RAF mediation. And are you in a position to shed any light on that?
Yes, I am. Not, unfortunately, yet full light, but the amount of light is increasing, Ian.
That's why I was very careful in the way I asked you, Herman. I don't want you to say anything that's out of line.
No,
but whatever you can say, you comfortable to say it.
I've got no secrets, Ian.
Yeah.
You were part of a very happy Zoom meeting between ourselves and some of our initial planned mediators and observers, and 2 people from the RAF in last week. I think it was on Thursday. On Friday, I received a call from Justice Ndluli, who's the senior manager in charge of the mediation pilot project, who told me that the acting CEO has now signed our memorandum of understanding. So that was the big thing that we were waiting for. As yet, I haven't received it. Justice said he's got to go and scan the document and send it to me. But he phoned me to say it is signed, and I'm sure he was telling the truth. The next step is that he and I are having a planning meeting tomorrow to plan the exact logistics of when and how the first mediation takes place. So I fully expect that the first case in that project will occur during this coming week, and we have all agreed that it will occur online. So between the plaintiff attorneys, the RAF, the mediators, the parties, everybody has agreed to that. So Ian, when that kicks off, that will be the beginning, I think, of a snowball. We've agreed to mediate 50 cases for the RAF for free, on the basis that they allow observers and co-mediators, which is part of our development and training process, to give exposure to people. They want to have some cases that are trial ready. In other words, all the bundles are done, expert minutes are done, all the expert reports are in. And they also want to try with matters that they have at an earlier stage for them to see what the effect is. And they've also asked us to try a certain number with co-mediators and another number with sole mediators, and we've accepted that. So the pilot project will be very useful and interesting as an investigative tool on the one hand, to measure how mediation works in RAF matters. And you will see, I've sent you a copy of our data acquisition sheet. We are going to acquire a lot of data in these 50 matters, which will be able to be processed and hopefully bring some interesting and useful statistics.
Herman, can I just make a comment? And really, I just want to, because I think you maybe being slightly modest in this sense, that this particular initiative is now involves the biggest litigator in the country, which is the RAF. The recent judgment found that over 90% of matters on the court roll in the North Gauteng court, in Pretoria court, are RAF matters. The same applies in Joburg, and I can assure you it's the same in KZN. I'm sure it's across the country. The RAF is massive, and the litigation that they do is really influences how all other litigation is conducted. And here we have, right at the inception of Rule 41A, we have an initiative in terms of which the biggest litigator in the country is now having a look at the viability of mediation. And I know that project that you've set up, and you talk about that data acquisition, the RAF is going to scrutinize that very closely. And so this particular initiative, I don't think it's overstating the case to say that it's absolutely crucial to how mediation is going to be taken up, and the attitudes that will form around mediation. And if the opportunity which is presented by Rule 41A is to come to fruition, then this project, in my view, is going to play a very important role. And my last comment on that is that typically South African, any new initiative comes born from struggle. And there is litigation around this very question of whether mediation is an appropriate model or not. The old panel attorneys look like they're sharpening their swords to attack that particular model. And so the mediations that occur now are going to come under very close scrutiny, not just from their attorneys and advocates, but from the courts. And so so I really wish you well for that project, and it emerges as in my view being a groundbreaking project, but also there's a tremendous amount riding on that project.
Well, thank you very much, Ian, and I agree with all your comments. One thing that I'm also pleased about, and this is maybe something for which we can thank coronavirus, is that by forcing the hand to allow online mediations, it also makes it possible for a thing that was going to be a Gauteng project to become a national project. In other words, there's no reason why you and Romany and Paul and JP Ellis, for example, can't take part in these mediations from your home or your office. And of course, Michelle,
I mean,
to take part. And I think that's great.
I know that.
So let me just also make use of this platform. Sorry, Ian, I just want to make use of this platform to extend an invitation to any mediators around the country who are interested in participating in the RAF mediation pilot project to contact SAMLA. The best place is to go to the SAMLA website, get yourself registered there as a SAMLA registered medical mediator. Anybody can do it. There's just a process, certain forms and documents you have to read and fill in, and we will include you in the RAF pilot project.
Thanks, Herman. Yeah, I think that's an important initiative. All right, thank you very much. We've heard a lot about cerebral palsy this evening. There's a lot of discussion around it, and we've done some work on that in the last few weeks. I'd like to bring Paul Delmeyer into the conversation at this point. I'm going to just extend this conversation for a few minutes to bring Paul in, and just to get his responses to what he's heard this evening. I mean, there's a lot, and also over the last few weeks, Paul, there's been a lot of development, and we've touched on some of the main features from the perspective of obstetricians and gynecologists, and particularly the obstetricians. Paul is very well qualified to speak on behalf of them. He is a very well-known figure within those circles, and actually we owe Paul a debt of gratitude for promoting this particular platform and to helping us to get some of the guests on the show who've been so useful. Paul, if you can maybe just give us your initial views on what you've heard this evening, and also over the last few weeks.
Thank you, Ian, and thank you for asking me to fill in for Johannes and Ishmael. It was a bit of a last moment. I put some questions to you, but first of all, allow me just to comment on what I heard this evening. And as Michelle said, it really has come. Mediation has really come to the fore, which we that started this whole initiative, and Herman was, we were involved in the South and you in the North, and we are absolutely convinced that this is the route. And as Michelle said, a new terminology has become available, which I didn't understand, but it's mediation advocacy, which is obviously a new name and a new concept. But mediation, and this has come out on a number of times, and Herman and I have spoken about it, and in the last webinar when I asked the question, is mediation is very poorly understood. And to doctors, it is even more so, because doctors, when they have an adverse event, look for a comfort zone. And all they do is contact the mediator and hope it goes away. So, and what Romany has said, we have to keep talking in mediation. And that to me is a key word, not to be told by the protection societies or the indemnifiers to say, just keep quiet, we will handle this, because that's what the doctor wants. And they don't understand the concept of negotiated settlement or of mediation. And Herman, I'm sure you will agree with me, and Romany as much. So that to me is at the heart. And if I listen to what's in this whole webinar and the previous one, is that mediation, and probably forced by Rule 41A, is come to the fore, and that is it has to be accepted as, because for the clinician to fork out the money to indemnify themselves is just not sustainable, not at all. We are going to lose our obstetricians, and as an obstetrician gynecologist, the fear is to actually practice obstetrics, and for that matter gynecology, because the next, and I'm not talking about the whole medical discipline as a whole, the next one, the target is endoscopic surgery, and our discipline in obstetrics and gynecology, there are 5 subdisciplines, and my real concern is, Ian, is that evidence-based medicine in the courts are not entirely weighed in the sense that it should be weighed, in a court of law. So those are my sort of immediate comments. I'm happy to answer the few questions that I put forward to you this morning, if need be. Thanks, Ian.
Thanks, Paul. All right, let's. I think that we're seeing a trend, and I'm just trying to draw these different strands together, because we start seeing patterns emerging, from various different quarters. And I mean, one of the key patterns is definitely this concept of mediation, how that's going to play out in the courts. And then at the same time, we're seeing a lot of development with around that cerebral palsy space. So both of those strands impact on your profession, Paul. And we've heard in some detail some comments on the expert opinion panel that I think there's been great work done with. Better Obs as a program that's been around for a little time now, but I think it really helps to set a standard. And when you talk about evidence-based medicine in the courts, there are differences in approach. The courts often deal with circumstances, as we've seen tonight, where it's not exactly clear what's happened, and so the courts need mechanisms to cope with that. And it's not always a black and white situation. And of course, we in a civil case adopt the balance of probabilities as the yardstick that we've got to follow. But we need to find a way, in my view, of dealing with the majority of these cases in a better way than what the litigation system has been able to do up to now, for a number of reasons. All right, I'm going to just start bringing things to a close. Roman, if we could have some closing thoughts from you, please.
Hi, thanks, Ian. And it's so good to see Paul and Herman there as well. They're both great friends of mine. So thanks for that. Thanks for bringing us all together. Yeah, these are such interesting times. Things are moving so fast in the CP sector, especially. And I'm just really excited, when sort of the medicine, what's the planning for medicine and the plans that the Better Ops project is going to bring in, or is bringing in at present, where that sort of starts taking effect. I think it's going to assist everyone greatly. Right now, as Stephen Killerman was saying on Thursday night, we are still needing to deal with the backlog. And it's difficult. And
yeah,
it's
that's right.
Yeah, so but we're moving in the right direction, and it's exciting. And as long as we start, as I said, carry on talking, but let's just bring it towards each other so we can we can make these things work then.
No, I agree, and I think that is an important point that Stephen made, and that is that Better Obs is really going to start playing out in the future. We've already got cases that before Better Obs, but Better Obs I think will start helping down the line. Michelle, maybe I can bring Michelle Poseman in. She can just have some final thoughts on now that she's heard people commenting on mediation and specifically with the comments that she's made. Is Michelle there?
Michelle seems to have just dropped off. I'm sure she'll be back shortly.
She just dropped off. As I mentioned her name, she
yes,
disappeared. All right,
as you said her name.
Yeah, I saw that. All right, Louis, let's get some wrapping up thoughts from you. Louis, I'm very pleased that you didn't disappear like Michelle, but now we're not getting much from you. Hi, Louis, are you there? No. Yes, you're looking a lot more relaxed now. Oh, good.
No, I've just been fascinated. Thanks, Ian. I'm just so glad to have taken part this evening, and I followed all of your other webinars, and it's just fascinating. I've really enjoyed them, and what I'm, we deal with a lot of case law on a lot of different topics. So we tend to sort of skip along the surface because we just engage with like reportable cases or interesting ones that pop up. But now that I've been discussing this Mayer's case with you and the others, it's so intriguing how these different threads on medical negligence are coming together. And I'm really going to follow it closely now and see how this develops, because that one case we had, there's such a beautiful quote in the beginning, the MSN and the judges.
Let me see if I can.
Yeah, it's MSN Judge Kately. These cerebral palsy cases. I notice in the Eastern Cape as well, there's judges that start off their cases where they're just so exasperated at the scale and the level of the damage that's happening daily. And Judge Kately just summarized it so well in the opening paragraphs about the double tragedy. So, yeah.
Let's actually have a... In paragraph 2, I'll read it out, Louis. And it's actually a good note to end on. I think maybe let's look at paragraph 1 as well. She says, it is tragic that this matter involves yet another claim against the MEC for Health Gauteng for damages arising out of negligent conduct by medical staff in a public hospital, resulting in the birth of a child who is now severely disabled by cerebral palsy. Judges in this division are now accustomed to presiding over these matters, which are, unfortunately for all concerned, and particularly for the affected families, all too frequent. In this matter, the child concerned is Kay. She's represented by her mother as the plaintiff. As this judgment demonstrates, there's a double tragedy inherent in matters of this nature. Not only are the disabled child and her family deeply and irreversibly affected, but so is the public healthcare system. This is because claims of this nature typically involve a substantial quantum of damages, often in excess of 20 million rand. These damages, if proven, are paid from the public healthcare purse, thus depleting badly needed resources that would otherwise be available for the healthcare needs of the residents of Gauteng, many of whom do not have the benefit of private healthcare. And Louis, I think you're so right. I think she sums it up. Those are indeed the issues. And I would also say this, that it's gratifying to see that the judges are well aware of the situation. And to go back to our conversation, we see that the judges being prepared to develop and prepared to be flexible. They obviously have to be conservative, because you can't have radical changes which one doesn't know how that's going to affect the system. But I think in an appropriate way, the judges have been prepared to be flexible, and we have seen developments. And let's hope that those developments within the mediation space, within the public healthcare defense, and with regards to this question of the onus and the burden of proof, all come together in a sensible and cogent way within our legal system. All right, I'd just like to thank everybody and wrap up. And it's been an absolute privilege for me over the last few weeks to host these discussions. And it's amazing what insight you get just from listening to people. And to everybody that's joined in, to those that have presented, and just those who've also just watched, I'd like to thank you all for your time and for your commitment. And I look forward to continuing these conversations in the future. Right, goodbye, everybody. Cheerio. Thanks very much.